All rise.
May it please this Honourable Court, my name is Chawaning and I am the lead counsel together with me, Ms. Norma Sari, and we appeal for the appellant Anwar Abraham. My Lord, the case before us today is to appeal against the decision of the High Court which found the appellant liable in defamation. This appeal rests on two principal grounds, which is the trial court erred in admitting the first defendant's WhatsApp messages as an admission of liability, and the second ground will be discussed by my co-counsel. First and foremost, the appellant submits that the trial judge erred in ruling the WhatsApp evidence as an admission. The appellant submits that the WhatsApp messages is not an admission under Section 17 of the Evidence Act, rendering Section 18 and 58 inapplicable. The statement, "I will not apologize until I get my money," is fake and does not give rise to any inference that the appellant committed the alleged offence or relate to the causes of action in dispute. Relying on Portuguese Trustnet and George Padmanabhan, a statement is not an admission unless it clearly suggests an inference relevant to the issue in this case. Accordingly, the trial judge erred in admitting the WhatsApp evidence as the respondent failed to discharge the burden of proving its admissibility as an admission. The plaintiff referred to Section 23 of the Evidence Act and submit that the WhatsApp evidence is inadmissible, citing the federal court case of Malayan Banking Berhad and Fusimoy. Letters written without prejudice are inadmissible in evidence because to enlarge the scope not to further the negotiation for both sides to come to a conclusion.
Counsel, in other circumstances where the communication does not expressly state without prejudice, how should the court determine whether the statement nevertheless forms part of without prejudice negotiations, and where the element of prejudice or settlement impact can be identified from content and context of communication?
My Lord, in determining whether a communication falls within the without prejudice rule, despite the absence of express wording, the court is required to adopt an objective approach by examining the content and context of the communication. In AB Chu Investment and Lim Juko, the court held that without prejudice communication are not confined to written correspondence, but may also extend to oral exchanges or conversation between parties. Accordingly, although the phrase without prejudice is not expressly stated, the statement, "I will not apologize until I get my money," when construed objectively, reflects an attempt by the appellant to negotiate a settlement with the respondent and should therefore be treated as falling within the scope of without prejudice communication. The appellant relies on Primala and Tuan Uthman Hashim. The WhatsApp communication containing a party proposal for a settlement, which ultimately did not materialize, cannot be relied upon as an admission of liability. Applying the same principle, the WhatsApp conversation in the present case merely reflects the plaintiff's willingness to apologize upon receipt of payment. Accordingly, such statement, when properly constructed in light of the case, does not amount to an admission of liability on the part of appellant. In drawing to close, the appellant referred to M.A. Clyde and Wong Ahmed, which the court states that an admission cannot be regarded as conclusive. Hence, even if such WhatsApp messages amount to an admission, the trial judge erred in ruling in favour of the respondent because the weight of such admission shall not be conclusive and the respondent had failed to prove his case against the appellant on the balance of probabilities. Accordingly, I respectfully pray this Honourable Court exclude the message and allow the appeal on this ground. Unless the court has further question, I now invite my learned co-counsel to address the remaining grounds.
May it please this Honourable Court, I appeal on behalf of the appellant. The appellant's second issue in the court is whether the learned High Court judge erred in rejecting the admissibility of the plaintiff's prior conviction on the ground that such evidence constitute inadmissible character evidence in a civil defamation action. The appellant respectfully submits that the respondent's previous conviction under Section 193 of the Penal Code is admissible evidence under Section 5 of the Evidence Act, as it is directly relevant to the facts in issue. In a defamation action, the central issue concerns the respondent's reputation and the extent of any reputational injury suffered. Accordingly, evidence demonstrating the respondent's pre-existing reputation prior to the publication is highly relevant to assist the court in determining whether the statement caused any further harm. In the present case, the learned High Court judge erred in law in excluding this evidence. The evidence satisfies the threshold of relevancy and constitutes a material fact necessary for the court assessment of whether the publication materially worsened and already damages reputation. Since the respondent himself alleged serious injury to his personal reputation, his pre-existing standing is clearly a material issue. My Lord, the appellant further relies on the doctrine of legal proof as recognized in Datuk Sri Anwar bin Ibrahim and Khairul Jamaluddin. This principle recognizes that where a plaintiff's reputation is already significantly tarnished prior to the publication, no additional reputation injury may be caused. In this case, the respondent's prior conviction-related jurisdiction finding linking him to pornographic scandal constitute a cogent evidence that his reputation has already been substantially damaged before the publication.
Counsel, the trial judge excluded this on the basis that it runs foul of the rule against character evidence. How do you respond?
Much obliged, my Lord. The appellant respectfully submits that the evidence is not tendered merely to attack the respondent's character. Rather, it is adduced because the reputation itself is a central issue in the defamation proceeding. Once the respondent alleged serious reputation harm, his pre-existing reputation becomes directly relevant. Further, under Section 52 and Section 53 of the Evidence Act, while character evidence is generally inadmissible in civil proceeding, it becomes admissible where character itself in issue or affects the assessment of the damages. In defamation cases, reputation is directly an issue. This position is supported in Ramanathan and Pinuting the Mill the Malay Mail, where prior conviction were admitted as evidence to the assessment and mitigation of damages. Accordingly, the respondent's prior conviction is highly relevant as it directly relates to the existing reputation at the material time. Given the respondent is a practicing and a prominent lawyer, it may be reasonably be inferred that his conviction under Section 193 of the Penal Code could have immediately and significantly impact his public standing. My Lord, the High Court judge's rejection of this evidence on the basis that it falls foul of the rule against character evidence is therefore enormous. This evidence is not adduced to unfairly prejudice the respondent, but to assist the court in accurately assessing the extent of the reputation harm. Finally, the appellant submits that the evidence carries a substantial probative value which clearly outweighs any prejudicial effect. The principle in Abordment and TP supports the admissibility of the evidence where it is probative outweighs its prejudicial effect. Here, the probative value of the respondent's prior conviction and related finding is significantly relevant to the issue of damages. For this reason, the appellant respectfully submits that the learned High Court judge erred in excluding this evidence. This evidence is plainly admissible under Section 52 and 55 of the Evidence Act. Much obliged, my Lord.
May it please His Lordship, my name is Mohammad Shabil. I appear as lead counsel for the respondent, Michael Waters, together with my learned co-counsel, Ms. Nurin Idina. We are here today on issue A regarding the admissibility of WhatsApp messages sent by the first appellant on 19 February 2024, stating that I will not apologize until I get my money. The learned High Court judge was absolutely correct in admitting the electronic message. The appellant seeks to completely exclude this vital evidence by hiding behind the shield of privilege. The respondent's clear submission is that this message is fully admissible under Section 17 sub 1 as relevant admission, authenticated under Section 90A, and completely stripped of any protection of Section 23. As a threshold matter of digital evidence, the WhatsApp messages satisfy Section 90E of the Evidence Act. Applying the landmark Court of Appeal decision of Pioneer Sabab and Tan Chow Fu, it is established that the instant message like WhatsApp are documents produced by computer, in line with the case of Instant Corps in Durian Berhad and Perfect Mix portfolios in Durian Berhad, where explicitly held that the Section 90A completely dispenses with the common law requirement of calling the human nature of an electronic statement. Here, the Ladyship Justice J.C. Evel Mary Peters opines that WhatsApp evidence should be categorized under Section 90A due to the fact that the output product is produced through algorithmic methods. WhatsApp is not merely an information fed by the use into the computer. It refers to the idea that WhatsApp messages are not raw, unprocessed text. They are data generated through algorithmic computational process within the WhatsApp software and server itself. Because the final output is structured by these algorithms, it is conceptualized as computer-generated data rather than purely human-composed documents. This means that the document encompasses Section 90A of the Evidence Act, provided that the document was generated by a computer in its ordinary course of use. The system's output is that what law recognizes, and because of this message was received lawfully on the device, the absence of the maker goes only to the weight of the evidence, not its threshold of admissibility.
Counsel, why should court interpret it as admission of liability?
To answer your Lordship's question directly on the substance of Section 17 sub 1, the core fact in this issue is whether the appellant acted with actual malice without completely shattering his needed defense of justification. By texting, I will not apologize until I get my money, the appellant made a devastating out-of-court admission. He implicitly confessed that he had never truly believed in the respondents committed a criminal offence under Section 420 of the Penal Code. Instead, he admitted he was using a defamatory press statement as a leverage tool for collection. Under Section 40, this reveals that he's too straight of mind, and under Section 8, it constitutes a subsequent conduct. The timeline is fatal for the appellant on 19 February. His manager, Mr. Indran, had already informed him that the dishonest check was a mere clerical error. Knowing of the truth, yet holding the respondent's reputation hostage for money is the ultimate definition of bad faith, as the federal court established in Shabazz and Tony Poatin Way. Maintaining a defamatory statement with full knowledge of falsity is the highest proof of true legal malice in our law. Thirdly, the appellant relies on Section 23 to argue the message is privileged without prejudice negotiation. The argument fails miserably on the facts. As established in Malayan Banking Fusi Moin, Section 23 only protects bona fide negotiations aimed in settling active disputes. We submit that this message had failed the Fusi Moin test in 3 distinct grounds. Firstly, it was a unilateral demand, not a negotiation. Second, the underlying issue was already settled. The replacement check was already in postal system, entirely outside of the plaintiff's control. Threats are not bona fide. Section 23 protects honest settlement talks. It does not protect the ransom demand where a politician uses a defamatory press statement to extract money. Therefore, my lord, the WhatsApp message is unprivileged, authentic admission against the interest that goes to the absolute root and malice of liability. The learned trial judge committed no error, law, or fact. We pray that the appeal on this issue to be dismissed with court. Much obliged, my lord.
My submission concerns whether the learned High Court judge erred in rejecting the admissibility of the plaintiff's prior criminal conviction and the Court of Appeal's finding that the plaintiff was the male actor in a pornographic video on the ground that such evidence constituted to inadmissible evidence in a civil defamation suit. My lord, the learned High Court judge was correct in law and fact to exclude such evidence. My lord, the general principle governing character evidence in civil proceedings is found under the Evidence Act 1950, Section 52, which provides that in civil cases, evidence of character is irrelevant unless character itself is directly issued. Further, Section 55 of the Evidence Act makes it clear that only evidence of general reputation or general disposition may be admitted and not evidence of particular acts. In the present appeal, the appellant seeks to rely on a specific prior conviction and a specific judicial finding relating to an alleged pornographic scandal. Those are plainly particular acts and not evidence of general disposition. This principle was clearly affirmed in the case of D.P. Vijayendran and Karpal Singh, which is a highly analogous to the present case. In that case, the defendant attempted to reduce damages in the second defamation suit by relying on allegations that the plaintiff was involved in pornographic films. The court rejected the evidence on two grounds, my lord. First, the evidence was particular in nature and therefore inadmissible under Section 55. Second, the alleged sexual misconduct had no nexus with the plaintiff's professional reputation, which was the subject matter of the defamatory publication. Likewise, in the present case, the defamatory words complained of the concern's honesty, integrity, and fitness as an advocate and solicitor. The publication accused the plaintiff of cheating under Section 420 of the Penal Code and being unfit for the legal profession. The alleged pornographic scandal concerns the plaintiff's private and personal life. It bears no relevance whatsoever to his professional standing as a lawyer. Therefore, the proposed evidence lacks the necessary connection to the defamatory thing complained of.
Counsel, if publication itself references the scandal, why is evidence irrelevant?
Much obliged, my lord. Mere reference to scandal does not automatically make the evidence admissible. The court must still consider whether it is relevant under Section 52 and 55 of the Evidence Act. Here, the evidence concerns specific past misconduct relating to the plaintiff's private life, whereas the defamatory sting concerns his professional integrity as a lawyer. Therefore, the evidence lacks sufficient nexus and remains inadmissible character evidence. My lord, the appellant attempts to argue the plaintiff is libel-proof, meaning that his reputation was already destroyed before the publication. Respectfully, such argument cannot stand in Malaysian law. Additionally, my lord, Section 43 of the Evidence Act also supports the respondent's position. Findings made in another case are generally irrelevant unless the existence of the judgment itself is an issue. Here, the appellant is effectively attempting to import findings from a separate criminal proceedings into this defamation suit. That is impermissible. As stated in Thompson and Church, the business of the court is to try the case and not the man. Therefore, the London High Court judge correctly exercised judicial discretion in excluding the proposed evidence as inadmissible character evidence. We respectfully submit that first, the evidence relates to a particular act and is therefore inadmissible under Section 52 and 55. Second, the alleged pornographic scandal has no nexus to the plaintiff's professional reputation, which is the subject matter of this defamation claim. Accordingly, we humbly pray that the appeal will be dismissed with cause and the decision of the London High Court judge be affirmed. Much obliged, my lord.
Having carefully considered the submissions made by both parties, I now deliver court's decision. First issue concerns whether WhatsApp message was rightly admitted as evidence constituting an admission of liability. In my judgment, the London High Court judge was correct in admitting the message. Applying the objective approach established in Anadagodan and Regina, a reasonable person reading the statement, "I will not apologize until I get my money," in its surrounding context, would reasonably interpret as an acknowledgement by the first appellant that an apology ought to be made in respect of the press statement, although intentionally withheld until payment was received. Such words are capable of amounting to an admission under Section 17 Sub 1 of Evidence Act. As for Section 23 of Evidence Act, I am satisfied that the without prejudice rule does not apply in the present case. Guided by the parties of A.B. Chu Investment and John Com, there is no evidence showing that both parties intended the communication to form part of genuine settlement negotiations. The message was merely a spontaneous unilateral remark and not part of any structured attempt to compromise the dispute. Accordingly, Section 23 is not engaged. Ground 1 of appeal is dismissed. The second issue concerns whether the learned trial judge erred in excluding the findings of the Court of Appeal arising from related criminal proceedings. In my view, the Honourable High Court judge committed no error. Applying the principles in D.P. Vijayendran and Karpal Singh, character evidence in defamation actions must relate to general reputation rather than isolated acts, and evidence must correspond to the particular aspect of character alleged to have been defamed. Section 43 of the Evidence Act further provides that judgment is unrelated proceedings are generally irrelevant, except in limited circumstances. The previous criminal proceedings did not determine the issue presently before this court, and therefore could not properly be relied upon to establish liability on indicate reputation at harm in the present defamation action. Likewise, in Pakul Prosecutor and Datuk Sri Anwar Bracket No. 3, the court recognized that collateral or prejudicial evidence may properly be excluded or expunged where it is unrelated to real issues before the court and carries the risk of unfair prejudice. The present proceedings were not intended to reopen or retry pornographic scandal. The court must remain directed towards defamatory publication that forms subject matter of the claim. In present case, the Court of Appeal finding relate to a specific matter concerning personal and sexual morality, whereas defamatory publication concerns alleging affecting professional integrity and financial honesty. These are entirely distinct aspects of character. As such, the evidence lacks relevance to the reputation that the respondent seeks to protect. Ground 2 of appeal is dismissed. As both grounds of appeal have failed, the appeal is dismissed in its entirety and judgment of High Court is affirmed. The respondent is entitled to cause. We further agree that the learned High Court judge that the court possesses inherent jurisdiction to expunge irrelevant or prejudicial matters from the record whenever necessary to preserve fairness and justice.